Good afternoon, good morning, good evening, wherever you may be watching us. This is Dr. Olu Asekun here. Apology for logging in late. I'm just coming from court. Thank you for joining us. Please remember to invite your friends, family, colleagues, and associates at work. Please remember to invite them so that they can also partake from this informational session. Today, as usual, we are going to talk about the recent updates. You do know that every week there are new updates on immigration. And to be honest with you, immigration is becoming extremely discouraging in this country. Practicing immigration law is becoming very, very discouraging because of what is going on under this current administration. And sometimes it is extremely difficult as a lawyer to defend your client, and that can be frustrating, especially for somebody like me who is very, very passionate about this job. And more, this government is they are intentionally creating roadblocks between lawyers and attorneys, between clients and attorneys regarding immigration practice, and sometimes it is very, very frustrating. Along the line, I will share my experience in court today, this morning. But before we go into that, I'm going to talk about the updates as usual. There are so many updates, and even right now, we struggle to catch up because the rate at which things are changing is becoming very, very difficult to catch up. And somebody wanted to buy one of my books recently, one of the books that I've written on immigration. And I was advising the person not to rely on the book because as of today, there are so many things in that book that we can't even guarantee anymore under the current environment. That book was written in 2018. The title is American Immigration Questions and Answers. But a lot of the answers provided in that book is no longer tenable today based on the changes under this new administration. And like I said, it's becoming more and more difficult to catch up. So this morning, I'm going to talk about 6 of the changes that came up between last week and now. The first one, I want to talk about a new trend at immigration, both at immigration interview and at immigration court. This one, there is no official policy on it, but I believe there's a directive to government lawyers and to USCIS officers, because I don't believe that this is a coincidence. I believe there is a specific directive to follow this pattern. The first trend is that now, when you attend an interview or when you go to court in a trial, the government, either USCIS officers or ICE lawyers, they are going to be asking you, when you apply for visa, what did you tell them you are coming to do in the United States? When you give an answer, there will be a follow-up question. Did you do those things that you tell them you are coming to do? How long did you tell them you are coming to stay in the US? How long did you eventually stay? Why did you not leave when you are supposed to leave? You see, the question itself is not the problem. The problem is the motive behind the questions. And what I've found out is that the motive is to disqualify the applicant, because now they are going to accuse the applicant of misrepresentation which is a ground of inadmissibility. For example, I conducted a trial today where the government lawyer was asking my client who came into the US on a student visa. The lawyer was asking my client, okay, did you attend the school? When did you stop going to school? Why did you stop going to school? Did you not, is that not misrepresentation? And so after asking all these questions, at the end of the day, during closing argument, they were now claiming that my client is not eligible because of misrepresentation, which of course will require a waiver. Remember, this was a final hearing that they brought this up. So there is no way we could have applied for a waiver before today. The hearing was this morning. So a lot of things are going on. Also, at immigration court, we have received so many requests for evidence or notice of intent to deny, where they were claiming that, okay, you told us when you applied for visa that you are going for a conference in New York. Record shows that you did not go to New York. You went to California, or you went to Texas, or you went to Florida. This is a new trend. Again, the problem is not the question itself. The problem is the motive behind the question, which is to find a way to disqualify the applicant. Because once they are able to establish that there is misrepresentation is a ground of inadmissibility, even though in some cases one can apply for a waiver. But in a trial where you did not expect this, talk less of applying for a waiver in advance. So these are surprises that are coming up both at immigration hearings and at immigration interviews. My listeners, I'm giving you this information so that if you have any pending application, it doesn't matter whether this application is pending with USCIS or the application is pending with the immigration court, you need to be prepared for those questions. You need to be prepared. And if you are in removal proceedings, you need to review your case with your lawyer. If you need to apply for a waiver, so that you do it before the final hearing date, you are not surprised on the day of the final hearing, or what we call merit hearing. So that is the purpose of this information, because this administration is looking for different reasons to deny applications. Remember, in one of our podcasts, I did mention that there was a memo or a directive again to USCIS officers and to USCIS lawyers that where there is a need to exercise discretion, that they should not exercise discretion in favor of the applicant. So in view of those kind of policy, if they are now able to establish that somebody has misrepresented fact, which will lead to inadmissibility, there is going to be a problem. It's going to be difficult to get the application or the relief approved. So, if you are in removal proceedings, please work closely with your lawyer. Make sure that they review all these things. Go back and try to refresh your memory. When you apply for visa, what did you tell them you are coming to do? Did you do those things? If you didn't, start thinking of a response to that question when you go to either your interview or your trial in court. Why did you not do those things? Is that not considered misrepresentation? You need to think ahead and take proactive steps. That is why we are sharing this information with you. The next thing I want to share, the next update that I want to share is that now, again, this is another trend. I'm talking mostly about trend this morning. This is another trend that we have seen at immigration interviews and at immigration court. This one is about those who have been married to a U.S. citizen before. If after coming to the U.S., If you have been married to a U.S. citizen before and you are no longer married to that person, if you remarry, any type of application that you have pending, either with USCIS or with immigration court, the trend that we have observed nowadays is that they are going to start asking questions about the previous spouse. Why am I putting out this information? We have seen situations where people don't remember any information about their previous spouse, especially where the previous spouse are Americans and they have been divorced for some time. I mean, we have seen a situation in our office here, one of the people we represented, when they asked questions about the previous spouse, the client didn't even remember the previous spouse name, talk less of remembering all the personal information. Again, this administration is looking for reasons to deny every application. I will not be shy to say this administration is not immigration friendly. So you want to take proactive steps. Go, if you have been married before, go back and refresh your memory. Go back and refresh your memory. If you cannot remember anything, go and look at the applications you filed at the time and refresh your memory with all of the information about your prior spouse. If you have been married before and you don't remember all of these things, that is going to be a prima facie evidence that the prior marriage is fraud. And of course, Section 204C of the Immigration and Nationality Act makes it impossible to get an approval if there have been a prior fraudulent marriage or an attempt to enter into a marriage for the purpose of evading immigration laws. So it is very important you are getting, because one thing I've seen from the recent trend is that because people didn't prepare for these questions, when they ask you, people are caught off guard. Oh, you've been married before. How many times have you been married? Okay, your previous spouse, what's the date of birth? Then the client is wondering, struggling to remember. Not many people remember all these things. So before you go for interview or before you even go for a hearing, go back and refresh your memory about all of the information about your prior spouse if you have been married before. The next thing I'm going to talk about, the Department of State. You know, we have said it several times that the Department of State is the agency that handles visa bulletin, not even USCIS. USCIS look at the visa bulletin the same way lawyers look at it, the same way you and I look at all these things. But it is the Department of State that is in charge. They are the one that determines how many petitions they have received in each category, and they are the one that determines when they have enough, when they have reached the annual limit. So the Department of State has announced this morning that they have reached the annual limit for EB1. They have reached the annual limit for EB1, that is for fiscal year 2025. They have reached the annual limit. Meanwhile, they also announced last week that they reached the annual limit for EB2 for fiscal year 2025. Now, there's no need to panic, because the good thing about this is that fiscal year 2025 is actually going to end this month. It's going to end on the 30th of September of this month. That is in a few weeks' time. So a new fiscal year 2026 is going to start on 1st of October 2025. So even though they have reached the annual limit for EB1 and EB2, is going to be, especially for EB1, is going to be a temporary setback, because by October 1st, they will start a new fiscal allocation. But for EB2, even though they will start a new fiscal allocation, because they are currently in 2023, it will not make a whole lot of difference, but at least it will move forward once they start the fiscal year 2026 on the 1st of October 2025, which is in a few weeks' time. So that is that. The next update that I want to provide is that for non-immigrant visas, effective immediately, this was announced on Monday, 2 days ago, and it is effective immediately. Applicants will no longer be allowed to apply for non-immigrant visa in a third country. So what that means is that if you have to apply for a non-immigrant visa, you have to go back to your home country or your country of legal residence. That is where you can now apply for non-immigrant visas. So for those who are in the US and they are in the habit of maybe going to Canada to go and stamp their H-1B, or to Mexico to go and stamp their H-1B or any non-immigrant status, that is no longer possible. It is effective immediately, effective as of Monday. So if you go to a third country now, not only are they going to deny you the visa, they are going to tell you to go back to your home country to go and apply. So that is a new policy of this administration as released by the Department of State. Applicant.
Even if an I-824 is filed?
Yes. Okay. So, it is a good point that that was brought up here by my team members. Even if you already have an existing I-824, you may need to now either file a new one or maybe send a letter to USCIS if a new one is pending, to change the location if your current request is asking for a third country. They are no longer going to process non-immigrant visas in third countries. It has to be your home country or a country where you are either a citizen or a national, or a country where you have legal residence. So it's no longer going to be possible to get non-immigrant visas in a third country. That is the next update. Okay, the next update after that I want to talk about is that before now, this is about ICE officers that make arrest. Before this administration, normally whenever an ICE officer is the Immigration and Customs Enforcement officers. Those are the people that make arrest. Those are the people that enforce immigration laws or a court orders and all of that. Normally, before now, before an ICE officer will leave his or her office, there are some paperwork that they are supposed to do. They are supposed to fill this paperwork. Okay, as an officer, I will be going to Dallas. I will be going to make an arrest. I will be going to arrest ABC. They will state all of the fact that they want to go and the mission that they want to go and carry out. But there is a new policy that eliminated those paperwork. So under the new policy, ICE officers are no longer required to fill this paperwork or to even provide all this information. So what that means is that an ICE officer who didn't even tell anyone where he or she is going can just stop somebody on the road and start making arrests without any paperwork. This is really, really unfortunate, but the truth of the matter is that this administration, they have scrapped the requirement for paperwork by ICE officers. This administration, they have scrapped it before they can make arrests. So now they can make arrests with or without any paperwork, without putting anything into writing, without even explaining their mission, where they are going or anything. They can just make arrests. That is that. I say that our time is gone, but it is important that I share this update. The last one I want to share, this one is really, really scary. It is scary, and I've seen the impact even just by mere announcement. This policy was announced on Thursday last week. And just by mere announcement, I've seen so many immigration lawyers who said they no longer wish to practice immigration law. You see, this is an attempt to scare people. This is an attempt to scare lawyers. This is an attempt to scare anybody who is willing to help immigrants. This is an attempt to scare anyone who is offering assistance to foreigners in this country. Under this new policy, USCIS has announced that they are going to add special agents with law enforcement authorities. They are going to add special agents with law enforcement authorities. This special agent will be able to carry guns and they will be able to make arrests. Now, for my listeners to understand what I'm trying to explain here, before now, there are 3 sub-agents under the Department of Homeland Security, and each of them, they have their individual responsibilities. The first one is the CBP, Custom and Border Protection. They are the one that admit people into the United States. They are the one that determine who enters the United States and who does not, either through seaport, airport, or even land port. They are the one that make that determination. The next one is ICE, Immigration and Customs Enforcement. They are the one that enforce immigration laws. They are the one that have the authority to arrest people, to detain people, to prosecute people. They are the one that take people to court. They are the one that charge people to court. They are the one that are responsible for notice to appear. They are the one that are responsible for prosecution of people who violated immigration laws. They are the one that follow through at immigration court, at the Board of Immigration Appeal, and file all this paperwork and represent immigration. They are the one that have the authority to arrest and detain people. But now, the third one is USCIS, United States Citizenship and Immigration Services. Statutorily, their responsibility is to adjudicate applications and petitions. That is their responsibility. This is where you have USCIS officers. They are the ones that conduct interviews, and that is their responsibility. Either employment-based application or family-based application, they are the ones that adjudicate all these things. Now, under this new policy, they are now saying that USCIS is now going to have enforcement responsibilities. USCIS officers or special agents that will now be attached to USCIS offices, they are going to be agents that have the authority to arrest people. They are going to be agents that have the authority to carry gun. And according to USCIS, they will be making arrest of any applicant determined to have filed a frivolous or a fraudulent application. And they will be arresting the applicant as well as their lawyers. This is why I said this is a fear tactics. This is an attempt to ensure that these people are not represented by lawyers. Because, number one, as a lawyer, how are you going to determine how are you going to determine ahead of time which application is fraudulent and which application is not? If two adults, a husband and a wife, comes to your office and they tell you that they are married, as a lawyer, how are you going to determine whether the marriage is real or not? Are you now going to turn to a private investigator and start going to their houses and start asking questions? Or what exactly are they expecting lawyers to do in these circumstances? How is the lawyer going to know whether these people are living together other than rely on the information provided by the client? Again, in my opinion, I believe that this is an attempt just to scare lawyers away from representing client, because a lot of lawyers will not want to get into trouble. They will not want something. They will rather prefer not to take the case rather than risk being arrested at immigration office. I believe that every reasonable American ought to protest against this policy. I will always say my own. I took an oath to be a lawyer, and I will remain a lawyer for as long as I live. There is no amount of threat, there is no amount of intimidation that can prevent me from practicing law. This is the profession that I've chosen to do, and this is what I'm going to do. There is no government, whether American government or any other government, that is going to stop me from the practice of law. This is what I desire to do. It is within my right to choose to practice law. That is why I went to law school. That is why I spent a lot of money becoming a lawyer. That is why I spent a lot of nights studying to become a lawyer. It's not that easy to be a lawyer. It is something that I desire to do. No government is going to stop me from doing this. You see, I said that this policy was announced on Friday, last week Friday. It will interest you to know that Sunday night, I came to this country from abroad on Sunday night. At the airport, I was singled out. The CBP officer asked for my passport, which I presented. He looked at my passport and he started asking me questions like, what kind of law do you practice? No, he started with, what do you do? I said, I'm a lawyer. What kind of law do you practice? I said, I practice immigration law. Where do you practice? I practice immigration law, and my office is based in Dallas. And then he said they are going to take me to a secondary inspection. So they took me to a secondary inspection. Of course, I don't have anything to hide, so I followed them. So we went to a secondary inspection. They asked me to go and get my bag from the where do you pick luggage? Yeah, from the baggage claim. Yes, they asked me to get my bag, which I did. So they opened all my bags, including my hand luggage. They searched every nook and corner of my bag as if I was a suspect, as if I've done something ridiculous. So I was looking at them. Of course, I don't have anything to hide. So in my hand luggage, they saw a wristwatch. They started asking me, where did you buy this wristwatch? Incidentally, it was a gift during my 68th birthday. So I told them it was a gift. I mentioned the name of the person that gave me the gift, that if you want to verify, you can call the person. So I'm not saying that this is directly connected to this policy. But what I'm saying is, I've been traveling for decades. I've been American citizen a long time. I've never been put into a secondary inspection. Over what? I was just coming in. I didn't even do any shopping where I traveled to. So there was really no basis for secondary inspection. But with this policy, it is very clear that this administration do not want immigrants to get help. They do not want foreigners to get help. They are really doing everything possible to scare away lawyers from representing people in this country. But I tell you, I am not scared. I am not scared. Whoever is watching, look at me eyeball to eyeball. I am not scared. Thank you. So let's go into questions today. Okay. The first question we are dealing with today. Good day, sir. How long does one have to wait for I-824 follow-up to join EB to be approved? Well, you have to check the processing time. Can you please help me check the processing time? Yeah, if you don't know how to check the processing time, you can go to our website, oluasekun.lawyer, and then click on resources, click on check the status of your case, and then scroll up, click on processing time. Excuse me. It will take you straight to the processing time. So you will see the processing time. But in the meantime, one of our team members will check for us. The second question, please, do you know the date they are currently working on at U.S. Consulate in Lagos for EB visa? Is there a way to determine that? I really don't have an answer for that.
Okay, but it depends. I'm currently working on it. It depends if it's family based.
No, he said EB, employment based.
Oh, well, the one that has been pending for the longest is one in the UK. Oh, Nigeria. I'm gonna say.
I don't think there's a specific answer to this because even in this office, we have employment-based cases that have been documentarily qualified since 2023. In fact, again, this is one of the reasons why I believe I may have been a target by this administration because I have actually filed a lawsuit against the Department of State for delay over this EB case that has been pending, that has been declared documentarily qualified since 2023. So after 2 years of waiting, I decided to file a lawsuit against the Department of State. So the Attorney General filed a motion to dismiss. I filed a counter. So right now we are waiting for the court to rule. That case was filed in Washington, D.C. So we are waiting. So it's really difficult to tell you precisely because, like I said, these people, there is really nothing that they are making it difficult to predict anything at all. I mean, I don't see why after a case has been documentarily complete, and this is a case that visa is current. It's not even, we don't have problem of visa availability. We don't have any issue. We already have an approved petition, and it's an employment-based case. So after all documents have been filed and received and acknowledged, and the National Visa Center themselves issued an email stating that the case has been documentarily complete. So I see no reason why we will not get interview date in 2 years. So that was why I went to court. So the case is still in court, and I will update my audience about the outcome of the case once we get a ruling from the court.
It was 3.5 to 25 months. It depends on the service center.
Okay, for the IA-24, so I have been told that it is anywhere between 3.5 months and 25 months, depending on the service center. But again, all these things are not reliable. We have seen cases where the processing times indicate that the processing time is about 6 months, and the case has been pending for over a year. And yet, when you try to do a service request, they will tell you that you still cannot do a service request. So they have just turned everything upside down under this administration. But we will continue to do our best. God will help us. Next question, please. Okay, good afternoon, doctor. Okay, this must be... Okay, good evening, sir. I got my green card, EB2, and applied for IA-24, followed to join for my wife. I'm looking into her moving to Ghana for study or work. Will this make them schedule an interview for her? Is that a continuation? In Ghana, if she becomes a resident there is a long wait. Well, like I said, I want my listeners to know that many of the information we are giving on this podcast, it is based entirely on information provided by USCIS, information provided by American Immigration Lawyers Association, information relied on based on personal experience and all of that. Because this administration is making it extremely difficult for someone to properly advise people. We do A today, tomorrow they tell you A is no longer possible. We do B tomorrow, next tomorrow they tell you B is no longer possible. So they keep changing the goalpost in the middle of the game. So it's becoming more and more difficult to really advise. Ordinarily, I would have told you that for as long as she's legal in Ghana, there should be no problem. But again, with the kind of policies coming out every day. It's becoming more and more difficult. I just mentioned one now about non-immigrant not being able to apply for visa in a third country. So I don't know. Tomorrow they may. Right now, that policy is limited to non-immigrant, but we can wake up tomorrow and they can extend it to immigrant too. So as at today, maybe I should explain in that order. As at today, yes, it should not be a problem for as long as she has residency in Ghana. But that is as at today. They can change it again tomorrow because the way the Department of State is changing policy now is extremely difficult to really catch up. But as at today, it is possible. Next question, please.
Evidence of legal residence and a valid residence address, residential address.
Yeah, that's why I said the
Like a
person must
contract
be
or
a
something.
permanent resident. If you are a permanent resident, you definitely will have address in Ghana. If it's a permanent resident of Ghana, they will have an address. You can't be a permanent resident.
They're living in Nigeria and they're permanent residents in Ghana and they decide
You can't be a permanent resident in Ghana if you are not living in Ghana. I assume.
But what do people do here? Sometimes they become permanent residents and they go back to their countries.
Well, I've been told that in addition to being a permanent resident, you also need to have a permanent address. A permanent address in Ghana.
Lease agreement or evidence that
Yeah, so they may ask for lease agreement or any other evidence that you actually live permanently in Ghana, in addition to showing evidence of permanent residency in form of legal status. Next question, please. Hello, sir. Thanks a lot for all you are doing, sir. Sir, when do I expect to have my green card after responding for the last 1 month? Well, I'm assuming responding to an RFE. Well, again, I believe that the person who is asking this question has been following us since we started this podcast. Based on what I know as of today, normally when you respond to RFE, they are supposed to take decision within 90 days. But that is the norm. There are a lot of things now that are not normal. So we don't know what they will come up tomorrow. But what I know, the normal thing, under normal circumstances, you are supposed to get a decision within 90 days. And if it is citizenship, you are supposed to get a decision within 120 days. That is the normal thing. In fact, that is the statutory requirement. But again, this administration, we have seen the posture of administration to obeying the laws of the land. And unfortunately, we have seen the court, especially the Supreme Court, giving approval to many of these things. It's really ridiculous. One of the greatest respect I have for this country is the rule of law, because I remember when I was taking my citizenship interview, one of the questions was, what does the rule of law means? It simply means that nobody is above the law. But apparently lately, some people are above the law. Some people do things that are not in compliance with the law and they get away with it. So that is where we have found ourselves. Next question, please. Good afternoon, sir. Please, is the new visa policy of applying from home country for immigrant or non-immigrant visa application? As at today, it is for non-immigrants. As at today, I don't know what can happen tomorrow, but as at today, it is for non-immigrants. Next question, please. Afternoon, sir. God bless you. What happens to a child who aged out under parent and filed F1 since January, but has not received any response from USCIS? With the new law, interview at home country?
That's the only question. There's no follow-up.
Okay, go back to the question. Okay, when this person says filed F1, I'm assuming that the person is here, the child is here in this country. But if this is talking about somebody applying from F1 from abroad, then the policy will affect you. The person will have to go back to his or her home country to go and apply for F1. But if the person is here in the US, you just need to apply for F1 change of status. Next question, please.
USCIS. So I think they're here.
Yeah, if the person is here, it doesn't affect people who are here. People who are here, they are just applying for a change of status. Hello, doctor. A friend asylum case has been transferred to immigration court for removal proceedings. His American citizen daughter will be 21 years a month before appearance. Can she file for him before then? Well, she cannot file for him before he turned 21. Or is this from the same person?
Yes.
Okay, USCIS transferred the case for overstayed visa. Okay, yeah. The child cannot file anything before turning 21. However, on the day that he turned 21, he can submit a petition for the parent. And of course, I know that the parent is going to appear in court 1 month after. So hopefully, within that 1 month, they will have received the receipt notice. Then they will be able to tell the court that they have a pending petition for alien relative, and then provide the receipt notice and the birth certificate of that child as evidence that they have a case pending. Hopefully, they will get a good judge, because some of these judges will tell you that they can't wait for the case to be adjudicated. And another thing I will also advise you, especially if you are going to engage a lawyer, tell your lawyer to file the I-130 with a request for expedited processing based on the pending removal proceedings. So that probably will help, although there is no guarantee that the case will be expedited, but at least there is no harm in asking.
And file online so they get the receipt notice.
Yes, you can also file it online so that you get the receipt notice immediately and be able to show something to the court. Next question, please. Okay. Hi, can withdrawal of I-687 application at an interview be used against you if you file for adjustment of status? In 2005, my friend paid a notarial and they put a lot of false information on form. Is that a continuation?
Yes.
So they withdrew it at interview because they didn't have the evidence. Well, I don't think so, because scroll back. Okay, yeah. I don't think so, because I remember the issue of the IA-67. That is the issue that involved LULAC settlement. And in that LULAC settlement agreement, there was an understanding that USCIS cannot use any information contained in the I-687 against the client. So for that reason, I know for a fact that they cannot use it, because if they do, that will be a violation of the agreement. So since it was a court settlement in the LULAC case, so they cannot use it against your friend. Next question, please. Sir, do you have any update for EB4 available in the incoming fiscal year? Well, incoming fiscal year is still going to be next month, 1st of October. So right now, we don't have any information. It's only the information provided by the Department of State. And like I said before, even USCIS themselves, they don't have any information. Visa bulletin is handled exclusively by the Department of State. They are the only one that can know in advance whether visa will approbate or retrogress. Is it retrogress? Don't let whether it will move forward or retrogress. So next question, please. Yeah. You see, English is not my father, it's not my mother's tongue. I learned it, so sometimes you you struggle with it. It's not natural. We are just
or progress.
trying to say it, but I'm sure my listeners, they understand. Okay, next question. Sir, what is the fate of those who are seeking a change of status in the US from one non-immigrant status to another, say from F2 to F1, who apply before this new development application? Well, it does not affect anyone who is applying for a change of status in the US. It is only when you are applying for visa. You know that when you apply for a change of status in the US, that does not give you visa. So if you step out of the country and you plan to travel, you will still need to go back to the embassy to apply for a new visa in your new status. So those are the kind of people that are affected, or anyone applying for original visa, any non-immigrant visa. But if all you are doing is applying from a change from F2 to F1 in the US, it doesn't affect you. However, if you plan to get F1 visa after your F1 change of status has been approved, if you plan to apply for F1 visa, then you will need to go back to your home country. You cannot do it in a third country. Next question, please. Sir, meaning ICE doesn't need warrant to arrest again. Exactly. That is what it means. If they don't need to do any paperwork, it simply means they don't need any warrant. Exactly. That is what it means. And that is why I said it is dangerous. Because before now, ICE officers are supposed to go to the office, articulate a reason why they want to go and arrest somebody, mention the person they want to arrest, mention the area they want to go. But all this paperwork, they have been scrapped. So it means that an ICE officer can just see you on the road and feel that they can arrest you. And like I said, the United States Supreme Court just yesterday gave the Trump administration a green light that yes, they can arrest anybody. They can do racial profiling. That is effectively what the Supreme Court just said yesterday. So that's why I said I really don't know what is going on in our country right now. I really don't know, because this is not the way the law is supposed to work. This is a country that somebody is only supposed to be arrested when there is reasonable suspicion and justification, credible reason to arrest somebody. But they are scrapping all those paperwork right now. ICE doesn't need any warrant to arrest. That is what the Supreme Court has said, and that is what this administration plans to do. Next question, please. Hello, sir. Thank you for all you do, sir. God bless you. I was denied B1, B2 visa in 2023 for assuming giving birth in US 20 years ago. As at then, it was classified as misuse of visa. Please move it forward. Is that a part 2? Okay. My child is 21 years now in final year college with a part-time job as an undergrad nurse and want to file for me. Can he file using my friends and cousins' affidavit of support as sponsor? Please, what's the wait time now, as someone once said 60 months plus? Well, to answer your question in a straightforward manner, yes, your son can petition for you. Talking about the affidavit of support, your son still have to fill the affidavit of support and be your sponsor. However, because he has only a part-time job, your friend or cousin can now do the joint sponsor. They can be the joint sponsor, but your son is still going to be the primary sponsor. Your son is still the one that will complete the affidavit of support before your friend or your cousin can be a joint sponsor and now complete a second affidavit of support as a joint sponsor. As far as the processing time is concerned, as I've been saying, that is increasingly becoming difficult to predict. But yes, it may take you up to 60 months. I mean, it even depends on the service center where the case is, because because you are outside the country, this is a case that is going to go to a service center, and I pray that it doesn't go to National Benefit Center. At the National Benefit Center right now, processing the I-130 there alone, I think it's about, was it 52 months? Yeah, it's about 52 months. And if the I-130 alone takes 52 months, then the process is not going to be completed in 60 months, because the I-130 stage is just stage one out of a 4-stage process. You are still going to deal with the USCIS, which is stage one. You are going to upon the approval, you are going to deal with National Visa Center, which is stage 2. And then once they are done, you are going to deal with the U.S. Embassy in your home country, which is stage 3. Once they give you the immigrant visa, you are still coming back to USCIS to pay the immigrant visa fee, which is stage 4. So it may end up being more than 60 months, but again, that will depend on the service center. Some service centers, their processing time is just about 12 months, but some, especially the National Benefit Center, is currently 52 months. Next question, please. God bless you and your team, sir. I got my EB2 NIW I-140 approved on Monday. My receipt date is January 18, 2024. So priority not current. What do I need to prepare for prompt application for I-485 immediately? Well, the first thing you need to do is to keep yourself in status. Remember, this is an employment-based petition. You cannot file the I-485 until visa becomes current. So you are not even in a position to file it right now. Oh, there's a part 2. Okay. Okay, what do I need to prepare for prompt application of I-485 immediately? Priority is current. My I-94 valid till April 2026. Well, again, it's still the same answer that I was giving before. What you need to do is to keep yourself in status until visa becomes current. I have no way of determining when visa will be current, because as at the last time I checked, I know that they are still in 2023. Do you know what month they are in 2023? So they are still in 2023. Based on my experience, it is unlikely that visa will be current before April 2026. But again, things change, because sometimes the visa retrogress and sometimes it progresses forward. So we can't really determine that. But the number one thing, and I will even say the only thing you need to do before visa becomes current, is to keep yourself in status. Because once you are in status, every other thing will be easy. I can't go into telling you what the filing fee and all of that will be right now, because we can't even predict what the filing fee will be at the time visa becomes current, because these people keep changing the rule. And the latest adjustment in fee was under this big, beautiful Bill Act, which increased filing fee substantially to a lot of applications, including applications that didn't even require a payment of filing fee before, even including VAWA. Right now, if you are in removal proceedings, you have to pay, I think, 1,500 per person in applying for adjustment of status. So again, it is too early to go into what that will be at the time, even what documentation. But if there is anything you need to prepare, one, you need to make sure you are maintaining legal status. And two, you need to have a birth certificate ready. If you don't have birth certificate, contact the National Visa Center, assuming that you are from Nigeria, but I see that this is a Nigerian name. So if you don't have a birth certificate, obtain attestation of birth from National Population Commission. Immigration don't accept affidavit of age anymore, or declaration of age. Anything short of birth certificate, especially from National Population Commission, or attestation of birth from National Population Commission may cause a delay in the processing of your application. So that is the most important thing you need to get ready if you don't already have that.
And it's September 2023.
Okay, they are still in September 2023. But again, like I said, I don't have a way of knowing how many petitions are in backlog. So we just have to wait and see. But keep checking every month. They will announce where they are. But right now, they are still in September 2023. So, this person, go back to that question. I think this person said the priority date is January 2024. I think I saw January 20.
The receipt date is January 18, 2024.
Yeah, that should be the priority date. So, yeah, visa may be current before the expiration of the I-94. Visa may be current. Just keep checking. It is possible that visa may be current. Yes. Next question, please. Sir, I submitted my change of status application after I came in via K1 visa and married within the 90 days. Unfortunately, during my visa interview, I wasn't given a copy of medical result. Go ahead, move it forward. But I submitted my vaccine certificate. Can this affect my application? I don't think I understand the
He
question.
submitted his shot record instead of a medical examination. He wants to know if that.
To USCIS,
Let me see.
I submitted my change of status application. I believe he wanted to talk about adjustment application since this is K1. Well, if you submitted the vaccination report instead of the medical report, because the medical report is supposed to be in a sealed envelope, which you are not supposed to open.
We have a similar situation. So they came on K1, and we did not submit medical examinations with it.
Okay.
They eventually issued RFEs
Okay.
for some of the members, but for the youngest one, they're asking for the one that he did back at the embassy before he came in on the K1. But he was also given the option of providing medical examination in case they cannot get the record from the clinic.
From the embassy.
Country of origin, yes.
Okay.
Yeah.
Okay. Yeah. So if you submitted the vaccination record instead of the medical record, which is supposed to be in a sealed envelope, immigration will issue an RFE. If they need it, they will issue an RFE and give you time to provide medical examination result. I don't think they will deny it because of that. They will issue an RFE and give you the opportunity to remedy it. Next question, please.
Okay, I think this is the second part. This one right here. Just thank you for your support. Okay, this one.
Okay. Good day, sir. Can an additional evidence be sent to USCIS after the initial document are sent for NYD and the deadline was in August 18? Thank you, sir. Well, normally, whenever they give you a deadline, especially with a notice of intent to deny, which has a statutory deadline of 30 days, normally after the deadline, they will not consider any new evidence. However, if I'm in your shoes, if you have new evidence, what I will do is prepare the new evidence, make sure they are copies so that you still keep the original. Attach a copy of the of the NOID, notice of intent to deny, so that it will have your alien number and everything, so that they will not misplace the documentation, and send it in. It is likely that USCIS will not consider it, but it's not going to harm you, because if that case eventually goes on appeal, they will see it, it will be part of the record. Whether it was considered or not, once you send it in, it will be part of the record. Make sure you send it with a trackable mailing so that you have record that it was submitted. So there is no harm. I mean, keeping it with you and not submitting it versus submitting it late. Which one is better? It's better to submit it late. It doesn't harm you. So I will still go ahead and submit it. But make sure you submit it in a way that it will get to your file. And the way to do that is to attach a copy of the notice of intent to deny. So send it in. That's what I will do. Next question.
No, you already addressed this one.
Good day, sir. Ekushe, thank you. The option on filing form does not have nieces, nephew, cousins. Does that mean one cannot file for nephew, nieces, and so on? Oh, yes, you cannot. You cannot. I've said it several times on our podcast that the way immigration law defines family is different from the way English dictionary defines family. For immigration purpose, the family of a U.S. citizen, they include parents, spouses, that is husband and wife, and minor children under 21. That is the definition of immediate family under immigration law. So if you petition for an immediate family member, that is why you are not affected by visa bulletin. So the issue of visa being current or no current does not apply to you. Going further, when it comes to extended family, again, the way immigration law defines extended family is different from the way English dictionary defines extended family. For the purpose of immigration law, extended family members, they include unmarried children of a U.S. citizen who are over 21. 2, married children of U.S. citizens who are married, and siblings of U.S. citizens, and of course, unmarried children of permanent residents who are over 21. That is the only category recognized as extended family under the United States immigration law. So under our law, there is no room for grandparents, there is no room for cousins, there is no room for nephew, there is no room for nieces, there is no room for all of that under the immigration law. Next question, please. I'm seeking your advice on navigating the F1 visa process for my daughter. She currently holds a valid 5-year B1, B2 visa and plans to pursue a master's degree in the US. Is that it, or there's a follow-up? Given recent policy changes and increased scrutiny, I'm concerned about the risk of applying for an F1 visa from abroad or potentially having our existing B1, B2 visa cancelled. Will it be advisable for her to enter the US on a B2 visa and change her status to F1? Your expert guidance will be greatly appreciated. Thank you. You see, this type of question give me, I don't even know, maybe, I don't know how to answer this question, because before now, I will have confidently tell you, oh, this is the best option. But right now, the current policy, they are so messed up that it is even difficult to know exactly which option will be better. You are right. These are two evils. If you apply for F1 visa at the embassy, if they decide to deny her, there is a risk that they can cancel the existing B1, B2 visa. I don't even know which country this person is from, but I can guarantee you, if you are from Nigeria, it is 99% certain that they will cancel the B1, B2. I've seen it lately, multiple times, even for people who have no reason whatsoever to be cancelled. They still went ahead and cancelled it. Probably because of the new 90-day policy. So they don't want people to still keep 5-year visa when the new policy is single entry, 90 days visa, 30 days maximum period. So it is very risky. On the other hand, should I say come in, apply for a change of status from B1 to B2 again under this new administration is risky. As I stated at the beginning of this podcast, one of the recent changes, they ask questions. What did you tell them at the embassy when you apply for visa? What did you tell them at the point of entry when you are coming in? So they are enforcing all those things now, and they are using it to claim that people are inadmissible. I mean, I was in court this morning. Somebody who came to the US with a student visa, F1 visa, they were saying that because she didn't go to school and she didn't disclose that she was not going to go to school. When she applied for visa, she told them she was going to school. She got here, she didn't go to school. Therefore, she obtained the visa by misrepresentation. And therefore, she's inadmissible. So when you see things like that, how do you now advise people? Do you advise people to go to the embassy and have their visa cancelled? Or do you tell them to come here and be denied based on inadmissibility, misrepresentation? So I don't even know what to tell you. The two options are risky. That is the truth. So there is no way she will enter the US today with a B1, B2 visa under the current arrangement and not be prepared to answer questions. When you are coming, this is what you told us. Why did you change your mind? So, I mean, the two options are not good. Is one better than the other? I really don't know. But if I'm in your shoes, what will I do? I probably would do the change of status. That's what I would do. Next question.
Today was only supposed to be an oral decision too. It wasn't even supposed to be a trial.
Yeah,
It already
I
conducted
mean,
the trial.
they keep changing the rule of the game. They keep changing the goalpost in the middle of the game. So it's making it difficult to really advise people. That's the unfortunate truth. Next question. Good day, sir, and thank you for all you do for us. Please, when will it be appropriate for me to withdraw my asylum application pending interview after getting married to a U.S. citizen? God bless you, sir. Well, if you are married to a U.S. citizen, submit your application first so that you are not in limbo. Submit your application, get a receipt notice so that you have something pending. Thereafter, send in a letter withdrawing your asylum application and indicate your reason for withdrawing as your marriage to a U.S. citizen and your preference to pursue adjustment of status instead of the asylum application.
I remember what you said in the past. The government mentioned that whoever has an application for asylum pending and they withdraw it, regardless of the reason, that they will be placed in removal proceedings.
That's why I said that they should file the adjustment
I
first.
think it's better to wait for the approval of the green card instead. So now they can prove that they have a new status. I mean,
Well, it's a good advice. I mean, I will put it out there. Like I said, this administration is making it difficult for people to advise. Well, one of my team members called my attention to the fact that this person may be placed in removal proceedings if the asylum is withdrawn. I was actually going to add to what I was saying before that the fact that you withdraw the asylum does not mean that they cannot make a determination that the application is frivolous. So that, because that one is a statutory requirement. If you go to page 9 of the application for asylum from I-589, you will see there on page 9 highlighted that the fact that an application is withdrawn does not mean that there cannot be a determination that the application is frivolous. So withdrawing it may not prevent that. So based on the totality of what is going on right now, maybe just sending your I-485 and the I-130, wait for interview, and probably if everything goes well, you can withdraw it on the interview date. or see if the officer will approve it. The good thing is that for as long as you are not in removal proceedings, USCIS will have authority over the adjustment application. But if you are placed in removal proceedings, USCIS will not have jurisdiction over the adjustment application. So that will automatically be forwarded to removal proceedings. But since you are not yet in removal proceedings, hopefully the application can be withdrawn during the interview. Next question, please. Good day, sir. Is it still possible for someone who has overstayed and get married to U.S. citizen apply for adjustment of status? Oh yes, you can still apply. The only thing is that during the interview, especially if you have overstayed, as I said before, all those questions are going to come up. What did you tell them when you are applying for visa? Where did you tell them you are going? Did you go to that place? For example, there is a notice of intent to deny that we just received on behalf of a client. In that notice, they indicated that when this person applied for visa, he told them that he and his family were coming to the United States for vacation. That was what he told them at the embassy. They went further to say that when this person was asked where the person was going to in the US, he told them he was going to New York. Then they went further to say that record shows that when this person entered the US, he came straight to Texas. He never went to US. So they see all those things. He never went to New York. So they see all those things as misrepresentation. Now, the problem with that is that once they ask you this question during interview and you admit that you misrepresented fact, that is going to be a ground of inadmissibility. It will now require a waiver. And that is one of the reasons why I'm putting this information up front, so that before you go interview, you need to prepare for this question. If you have a valid reason why you didn't go, you should state it and not admit to misrepresentation. Because the moment you admit to misrepresentation, it means that you are inadmissible, and then a waiver will be required. One thing I can tell you, I've been doing this job for several decades. I have never, until this year, until this administration, I've never filed a waiver application that was denied until this administration. I have a waiver for the first time, a waiver application that was denied. And if you look at all the reasons for the denial, these are specific reasons that were addressed in my brief when we submitted the waiver application. But apparently, they disregarded everything we said. They even went further to say that the hardship information or supporting documents we submitted, they were outdated, that they are not recent. There are all kinds of things, forgetting that it took time for them to adjudicate the case. But again, as I said, they are just looking for reasons to deny at this time. So if you already know that these questions are coming, you need to prepare a response for those questions. That is the purpose of giving you this information. Next question, please. Good day, sir. I got married in January 2024 and went for interview in November. Till now, I'm still waiting. No response from them. Is there a part two?
I guess they just want to know what to do, why.
There's a part two?
No.
Oh, okay. Well, again, under this administration, they have hired new people who will be conducting site inspection. And I remember, I don't know whether it was last week or 3 weeks ago, I talked about neighborhood investigation for those applying for citizenship. The same thing is also applying to those applying for green card, especially based on marriage. And with the with the new introduction of a special agent who will be armed and will be present at USCIS offices, I want to assume that they are really going to enforce this site inspection. So remember, January 2024, that was under Biden. So every pending application that were filed under Biden and has not been adjudicated, majority of them, they are being revisited right now. They are being re-adjudicated at this time. And many of them, especially family-based applications, they are going through rigorous screening in compliance with one of the president's executive orders that require rigorous screening of immigration benefits. So they are going through all of that right now. So all I'm just going to advise you is to make sure that you put your house in order so that nothing comes to you as a surprise. Next question.
We've gone to the limit, but there's still 3 more questions. Do you want to address them?
2 more?
3.
3. Okay, yeah. We stop it at those 3. Huh?
They're all follow-ups.
Yeah, let me answer all of them. We stop it at those 3. Okay, can you briefly explain the LULAC settlement? I tried searching it, but it's confusing. Well, the LULAC settlement, what it means was that I think it was in 1992, when Bill Clinton was president, there was an amnesty that was passed by the US Congress at the time. So many people attempted to apply for that amnesty and they were turned down by USCIS, either on the ground that they were not eligible or for some other flimsy reasons. LULAC is one of those non-profit organizations that was representing the interest of the Hispanic. Do you know the full meaning of LULAC?
I'm looking at that.
So they are one of those non-profit organizations that were representing the interest of the Hispanic community in the United States. So they file a lawsuit against immigration that when Congress passed the Amnesty Act, they expected everyone who is physically present in the US at the time to apply. So for USCIS to turn down some of them, that it was contrary to law. So when they filed that lawsuit, USCIS decided to settle the case. Now, part of the grouch of LULAC in that lawsuit was that the intimidation at the time prevented a lot of people from applying for the amnesty because of fear that they will be arrested, or that any information they provided, immigration will turn around and use those information against them if the case is not approved. So many people did not apply because of those fear. So when immigration offered to settle the case, LULAC made it as part of the condition of settlement that anyone who apply under that amnesty at the I-687, that any information they provided in their application cannot be used by USCIS in any subsequent application. And USCIS agreed. And then they submitted that settlement agreement to the court, and the judge signed off on it. So that is what LULAC settlement means. So if you can show that you actually filed I-678 at the time under the amnesty, that is application for temporary status. I believe that's the title of that form at the time. So all you need to do is that under LULAC agreement, USCIS cannot use any information included in that form against you in subsequent application. If they do, that will be contempt of court. So you can go back to challenge that decision. So that is what. Did you find the full meaning of LULAC?
League of United Latin American Citizens.
Okay. The full meaning of LULAC is
League
League
of United
League of United
Latin American Citizens.
Latin American Citizens. League of United Latin American Citizens. I even though I didn't remember the full meaning, but I knew that it was an Hispanic organization. So League of Hispanic.
League of United Latin American Citizens.
Okay, at least they got the LULAC thing has stuck in my head, so I didn't even. And again, this is something that ended a long time ago. I mean, I think it ended on February, April 30th, 2001. So that was when the amnesty ended. But we still use it for the purpose of Section 245I. Those who entered without visa or those who entered IWI, they can still adjust based on Section 245I, based on that settlement agreement under LULAC. Okay, next question, please. Sir, what if someone give birth after document complete stage for EB followed to join for spouse, or after the interview has been scheduled? Can someone still add key to application? Yes, you can still do so. If the case has been forwarded to the embassy, you will need to contact the embassy and provide the child's birth certificate. If the case is still at the National Visa Center, you contact the National Visa Center and provide the child birth certificate. The MVC or the embassy will issue invoice and ask you to pay immigrant visa fee for that child. But yes, they can still be added. Next question.
This is the last one. Okay.
I want the person asked. Sorry, go to the end. They asked because they go to the very last one.
No, the last one.
Yeah. So she's saying that it was filed in 2005. I looked up the deadline. So the deadline to file an application under LULAC was December 31st, 2005.
Yeah, what's the question?
So they're saying, okay, thank you. The I-687 form was filed in 2005. So I guess it doesn't qualify under LULAC.
It does. It does.
Yeah.
It does, because the issue here is not about the eligibility requirement for I-687. The issue is more about the information provided in the I-687, whether USCIS can use that information against the client, which the LULAC agreement forbids. So it is relevant. Go back to that question that I'm here to answer. Yeah, I'm not in removal proceedings. I'm awaiting. Which question is that? Okay, the one that want to withdraw. Yeah, that's what I said in my answer. I said that because she's not yet in removal proceedings, that USCIS will still have jurisdiction over the case. So she should attempt to withdraw it at the interview, because they can still approve it because there is no impediment. If it's already in removal proceedings, because they cannot approve it, they will still send the I-485 back to the immigration court. But because she is not in removal proceedings yet, then USCIS can still approve the green card. So that's what I said. So I knew she was not in removal proceedings. So the last question.
That was it.
That's it. That was it.
What about the one that says I'm in something?
You said we will stop here.
No. Oh, is that a new one that came after that? Oh, okay. What's the time now? Okay, I think we try. How many more how many more came after? I'm just trying to see, because I wasn't here 2 weeks ago, so I'm just trying to cover as many as possible. Go ahead, let me just answer them.
Okay. 2.
Okay. Good day, sir. If a minion, what does that mean? What's minion? If a minion has been filed,
I think minor.
or maybe you wanted to write minor, okay. If a minor has been filed for and now is 21, what will happen? Well, that is Child Status Protection Act, assuming that you meet the requirement. if the petition has been approved, but the adjudication is, or even if the petition is pending, but if it is approvable and visa is current, and then visa has not been current for more than 1 year and you have not applied. If you meet the requirement of Child Status Protection Act, the fact that a child turns 21 by itself is not an issue. I think we have a podcast on Child Status Protection Act. Please go back to our YouTube channel and search Dr. Olu Asekun podcast on Child Status Protection Act, CSPA. Next question, please. Good day, sir. God bless you. Amen. And you too. Okay. I have a pending 751 for 4 years and a pending N400, but my spouse is late. With this new policy, what you won't expect? Well, I'll tell you, with this new policy, despite the fact that your spouse is late, there is tendency that immigration will still conduct neighborhood investigation. They will still conduct all of those things. So I don't know if you have relationship with your in-laws. I mean, if you didn't, maybe you want to reestablish relationship with them, because under the new policy, they will still do the neighborhood investigation. So which means they will talk to your in-laws, they will talk to people in the neighborhood of the address where you used to live with your spouse. They will still do their investigation. They will still use the public record and all of that. So the fact that your spouse is late is not an excuse. You still have to ensure that you put your house in order, especially because of the N400. Next, or that should be the last one.
Well, one person just said thank you. Go to the one after.
Okay, thank you, sir. You are by far the best immigration attorney on YouTube. Thank you. You take your time to answer questions in detail. It is greatly appreciated. God bless you. Amen. You too. Is that all?
Someone asked how to contact us. I responded to them in the live chat with our website.
And then this last person, she's thanking you too.
Okay. Thank you, everybody. In view of all the things that we have been saying, I want to implore you to stay out of trouble. There is a saying where I come from. The person who is to be killed should not wet himself or herself with gas. So if you do, you are making it easy for them to be able to kill you. So I'm going to advise you, please stay out of trouble. I hope to see you again next week. Until then, I remain yours truly, Dr. Olu Asekun.